Companies in blatant violation of labour laws set by Telangana government have put many employees under stress. Now, a group of techies have decided to challenge these conditions that they call are against their fundamental rights. Vijay Gopal, a social rights activist from Telangana, filed the PIL in Telangana High Court against the violation of Shop and Establishments Act 1988 by the IT companies over leave policy, notice period, non-payment of salaries in time, companies making employees work for more than 48 hours and not even paying OT, and also excluding break and lunch time from the calculations of the weekly hours. The law states that employees can't be asked to work for more than 8 hours per day and 48 hours per week and should get at least 39 days off every year.
So imagine we are in a country where we are made to work on our own Independence Day, but we are given off on an Independence Day which is not ours. Now certain things like these has to be put before the court, and the court has to decide that on the name of commercial activity, the basic structure, the patriotic feeling of a person should not be touched at any length, or no matter how small extent it might be, but it should not be touched. Because if this is allowed to happen, there will come a time when people will will not have much respect for the
country,
Independence Day or whatever. So it is not only that these techies or other employees are working, this is going to affect their family as well. Since these companies have come in the last 20 years, most of the employees are in the age of 30, 40 and all. So all these people will have certain children. So this will also go to them. And because of this overtime, there is no limit for overtime and all. People have been working more than they are supposed to, just because they are getting money. Now, in a effect, ripple effect, this is affecting their family and personal life. I feel fortunate that I filed this, and I hope that court will give the right judgment.
Now, there are 4 specific issues that we've approached the court with. Number 1, as per the law, there are supposed to be 15 paid leaves, 12 sick leaves, 12 casual leaves, and about 9 holidays under Section 30, Subsection 5 of Shops and Establishments Act, which is totaling up to 48 leaves per annum. However, each company has its own policy of 10 leaves, 15 leaves, 18 leaves, and so on, which is depriving people of their own basic rights. Having said that, the second issue is the weekly hours. Ideally, India is still in the concept of working for 6 hours a week rather than 5 hours like any of the Western countries. So 48 hours is our limit, because 8 hours a day into 6 days amounts to 48 hours. However, the law also restricts you that if in case you're working anything beyond 48 hours, you're supposed to be paying the employee overtime, and overtime cannot be more than 24 hours in the entire year. And 6 hours is the limit on a weekly basis. So any contract or declaration forms or consents signed which is contradictory to the law of the land does not stand valid as per the law. The third point is the notice period, which is the biggest exploitation that is happening in the industry, and IT employees being on the receiving end of it for a very long time. As per the law, notice is supposed to be only 15 days, and that too if the employee so chooses to serve after he or she resigns. But there are companies with 30 days, there are companies with 60 days notice, and and in fact one of the party number 2 in our case, which is Accenture, is on a 90-day notice period, and they're making every employee sign it, which is absolutely illegal. So that's third part. Fourth part obviously is that the expectations of employers, I think it's more of a generational gap, is to be available on weekends, be available on social media, which is through WhatsApps, or attend meetings or calls from home on your holidays or weekly offs, is something that's mounting to harassment. So that's the fourth point that we have mentioned in the PIL, asking the High Court to direct the department to make policy on the lines to ensure that the basic human rights, basic employee rights are protected of an employee, and as to what Labour Department of Telangana has been doing for the last 30 years, as to why it has failed in implementing these basic laws and why none of us are aware of it. So the prayer is to ensure that these 4 points at least, which have no exemptions whatsoever, as some companies are claiming that they do, exemptions have never been provided to anybody on the 4 points that I've spoken of. Plus the worst part is the employers are, while they are calculating weekly hours of employees, they are not including the break and lunch in it, which is the biggest, I think, the fraudster way of calculating the hours, because Labour Department through RTI application that we filed has confirmed that the break and lunch is supposed to be part of the calculation of hours when you're calculating weekly hours.